now calls 126130, State of Kansas versus Christopher Shawn Adams.
May it please the court, Chris Elsliger, Deputy Solicitor General, appearing on behalf of the state. And again, I'd like to reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
This case brings us to the intersection of the court's truth-seeking function and an individual's Fifth Amendment right against self-incrimination. And generally speaking, when these two come into conflict, the Fifth Amendment right wins. However, the law has mechanisms to eliminate that conflict. And one of those mechanisms is immunity. And both this court and the United States Supreme Court have held that a grant of use and derivative use immunity is coextensive with the Fifth Amendment right against self-incrimination. That means someone that has been granted immunity cannot refuse to testify on the basis of the Fifth Amendment right. And that's what happened in this case. The witness, Lang, was granted use and derivative use immunity. However, the district court and the Court of Appeals majority here chose to boldly go where no court has ever gone before, and held that not only does the Fifth Amendment right, or the Fifth Amendment, give you the right to refuse to testify on the grounds that it might incriminate you, but it also gives you the right to refuse to testify because you don't want to tell the truth.
Just so I want to make sure I'm not oversimplifying the case, but the immunity that the state offered boils down to, if you come into this proceeding and tell the truth, we won't use that testimony in your perjury case, which was pending at the time. Is that all we're talking about, or is there something else?
Well, it was use and derivative use immunity, meaning we couldn't use that, whatever she said, for anything other than what again, both statutory law and case law have said that, the Fifth Amendment doesn't grant a witness a license to lie. So you can never grant immunity for perjury, meaning future perjury. Now, they couldn't use any statement she made to prove the prior perjury. And that, the county attorney made that clear. That was, they had no intention of doing that. He granted her use and derivative use immunity for anything she could have said on the stand that might incriminate her. And again,
right, but I guess I was maybe oversimplifying it a bit, but the real threat was this pending perjury case.
Correct.
And so we just want to make sure, even though you can't use it for anything else, but real sure that anything she says in the trial of the other defendant doesn't get put into the perjury case to show, aha, see, you perjured yourself before.
Right. And that was made abundantly clear by the grant of immunity.
What wasn't the threat actually the promise of the prosecutor or statement by the prosecutor that if you testify at Adams' trial like you did in prelim, you will get an additional perjury charge?
I don't know if the prosecutor ever said that. That was her fear. I don't believe the prosecutor ever threatened that he would do that. Although obviously that is a logical conclusion, but
okay. And then I think the majority on the Court of Appeals took issue because there's this sort of built-in assumption that testimony was false. But what's happened with the underlying perjury case, the only filed perjury case, in the time that's unfolded since the Court of Appeals opinion and where we are today?
It went to trial. She was found guilty of perjury, and she filed a notice of appeal. I don't know if the appeal has been docketed.
And does, that seems to at least strike at sort of the heart of the majority's analysis of the Court of Appeals that sort of took issue with this assumption that that the dissent at least was presuming that preliminary hearing testimony was false. what can we do with that conviction? Is that, I mean, does that lend enough credibility to truth or falsity? Or does it even matter whether the testimony was true or false?
Well, I've always taken the position that it really doesn't matter. It did seem to be important to the majority. And as I point out in the brief, though, the majority kind of ignored the fact that the judge at the preliminary hearing made a credibility determination, said he didn't think she was truthful. It's also disturbing because it kind of shows a certain breathtaking amount of cynicism about the ethics of prosecutors to suggest that a prosecutor would charge perjury just to try to manipulate the future testimony. The prosecutor is ethically bound to only file charges which he thinks he can prove beyond a reasonable doubt, and has probable cause, and so on. But then beyond that, as the dissent made below, and as we made in our brief, every witness that comes into a trial has the danger, the risk of being charged with perjury if they get on the stand and lie. And every witness, witnesses don't come in a vacuum, right? Lawyers don't just call witnesses out of the blue. Every witness has prior statements, whether they've made them to police or to investigators, to other witnesses, statements they made at the scene, maybe on camera. There's always prior evidence that if the witness takes the stand and testifies contrary to that prior evidence, they all run the risk of a perjury charge, even if they've been granted immunity. And the case law has made that abundantly clear. Only the majority below has made this ruling. I could find no other court in the country that has agreed with the majority opinion here. And the majority even went so far as to suggest that, kind of what you said, that the threat, not even if she hadn't been charged, that just threatening her with a charge of perjury would be enough to give the Fifth Amendment right. And other courts around the country have seen that very fact pattern and said, no, that's wrong. As the U.S. Supreme Court said in Applebaum, there's no right to anticipatory perjury. Okay, so she really wasn't in any different position than any other witness. And the problem, I mean, the rationale of the majority below is really, I mean, it's really disturbing because in my view, it both validates and encourages perjury. I mean, if the prosecutor ignores the perjury at the preliminary hearing that he's seen himself and that the judge has identified as probably false, then he essentially validates that if he does nothing, and he encourages the witness to just go to trial and perjure herself again and commit the same perjury at the actual trial. So that can't be right. But if the prosecutor charges perjury, according to the Court of Appeals below, then he creates a new Fifth Amendment right for the witness that did not exist before, and that would not have existed, just kind of out of whole cloth, out of thin air, is now created, that gives the witness the right to refuse to testify at trial. And I was thinking about all the different permutations this could take, and I thought, well, this is, one thing that hit me. I mean, organized crime would love this. I mean, could you imagine if the Godfather gets charged with a crime, and the witnesses against him are all his henchmen, and so they come into the preliminary hearing and they just blatantly lie. They lie and exonerate him. And if the prosecutor charges them with perjury, well, come trial for the Godfather, they just say, well, Fifth Amendment. And then there's no evidence, Godfather walks away. Or since they got away with perjury before, if the prosecutor doesn't charge the perjury, he essentially validates it. They come to trial and they can, again, give the exact same testimony, exonerate the Godfather. Yeah, they might get charged. They take one for the team later on, but the Godfather walks. This rule makes no sense. The Court of Appeals decision is simply, it's illogical, and it goes against all the case law involving the Fifth Amendment and where it intersects with perjury. The dissent, Chief Judge Arnold Berger got it right. She went to great lengths, relying on the Applebaum case, which I think is the appropriate precedent to rely on. And if there aren't any further questions on that, I would simply urge you all to agree with Chief Judge Arnold Berger and reverse the Court of Appeals majority in the district court below. Thank you.
May it please the court, Heather Fletcher appearing on behalf of appellee Christopher Adams. Clearly, the appellee does not agree with opposing counsel. It is our position that the Court of Appeals actually did get this right. The circumstances in this case, as I think everybody's aware, are pretty unique. I could not find a case either that was directly on point with the circumstances that we are dealing with here today. Ms. Lang was a state's witness who the state had endorsed, subpoenaed her, and to come to the preliminary hearing of Mr. Adams. She did that. She testified, and at that point, the state then decided that what she had testified to was perjury, and then made the decision to charge Ms. Lang with perjury related to that testimony that she offered at the preliminary hearing. They also filed an affidavit setting out what they believed was perjury that committed by Ms. Lang. They then subpoenaed her to testify at the trial of Mr. Adams, where the same set of facts were at issue. The state had that discretion whether to charge Ms. Lang or not charge her. They had the discretion to decide what to charge her with and when to charge her with it. They chose to charge her when they did, and that was their decision. They then created this situation where they wanted to bring her back, put her under oath, and if she testified consistently with how she testified at the preliminary hearing, they were intending to charge her again with a second.
Opposing counsel said there's nothing really in the record, just this is a factual issue, to show that they actually verbalized that or conveyed. If you testify the same way as in the preliminary hearing, then you'll be subject to a second charge. Is that just what she was thinking and her lawyer was thinking, or is there something in the record to show that they threatened her?
No, actually, I believe it is in the record that the state noted during preliminary hearing, as he was developing this perjury concept during the preliminary hearing, he made it clear that if she testified that way again, if I recall correctly from the record, I don't remember the exact quote, something about the effect that he would charge her with perjury.
Which he
preliminary?
did.
Yes,
But
he absolutely did. And then in chambers, he reiterated that the day of the jury trial.
and that is in the record?
I believe it is, yes.
A conference in chambers?
I believe it.
And
it
what
was-
did he say? What did the state say? Sorry.
I would have
that-
to look here in my brief. I believe I included it in my brief.
Was she in chambers?
Yes, Your Honor.
She was in chambers right before trial.
Yes. The scenario was the jury was in the courtroom. We were in chambers for preliminary matters. The court reporter was brought in. The state was there. I was there. The defendant was there. Miss Lang was called in. Her counsel was on the phone by conference call. And it was on the record that she was put under oath. She asserted her privilege at that point, and all of that should be in the record that was presented to the court.
Right, but did they say, I mean, that was the motion, for, I guess, to advance the Fifth Amendment privilege against self-incrimination. But did they say at that point is, if we do get you on the stand at this trial, then you're going to face a second perjury charge?
If I recall correctly, the attorney for Miss Lang indicated that it was his belief that her testimony would be consistent with her preliminary hearing testimony. And it was the state's position that there was going to be a second charge if that was.
That was verbalized at the.
I don't have that directly in front of me. If I recall at some point, because I recall the court had, the judge had even mentioned that that the state had made it clear that they intended to charge her again. if that was consistent. And she was in a situation where if she came in and testified consistently, then she was subject to a second perjury charge because they had already charged her and claimed that what she had testified to previously was perjury.
But why does that matter legally speaking? Why, even if that was verbalized to the witness, how is that any different from a prosecutor just saying, if you lie, I'm going to charge you with perjury?
Well, I think it's a little bit different in this situation because they had already charged her
Yeah,
at that point.
it has more credibility. It's not a
Absolutely.
bluff,
Yes.
but legally speaking, why should that matter?
I-
A prosecutor's always entitled to inform a witness that if they don't tell the truth, they may be subject to a perjury charge, correct?
Correct. And I would agree with that. I think what is different in this situation is that it wasn't just a potential threat at that point. It was, she had already testified, they had already charged her, and that charge was actually pending. So that was a reality. It wasn't a, oh, if I
Right, so
did
my
this-
question is, why does that legally matter? I
think it-
understand that it psychologically matters. It puts more pressure on the
Sure.
witness. But legally is, with respect to the Fifth Amendment, why should that matter?
Well, I think that it matters because she's being put in a situation where she either testifies consistently with what she testified previously and faces another felony charge, which is highly likely to happen since it already happened before.
What's wrong with that if her testimony is untrue?
Because at that point, there had been no determination by an independent fact finder whether her prior testimony was true or not.
Sure.
So the county attorney was being allowed to essentially insert himself as the judge at that point
No,
and say it was false.
again, I'm having a hard time seeing the distinction between that witness and the witness who has not yet been charged with perjury. In other words, they're all subject to the criminal justice system. And if a charge is supported by probable cause, that individual is going to get bound over for trial, just like the witness in this case would be.
I think this is different from just an average witness. And it comes down to that distinction that they had already charged her for that prior testimony, and then they subpoenaed her to come to court and testify again about this, essentially the same set of facts. And so she is put in a position that either she testifies consistently and gets another perjury charge, or if she changes that testimony, then they'd already charged her, I believe it was either another count or in the alternative, the interference with law enforcement from the night of the actual interview. So
Wouldn't she have had use immunity derivative from her subpoenaed testimony with respect to any previously either charged or uncharged crime?
I don't believe that she would have at that point.
Why not?
Well, I mean, none of that was,
Isn't that the scope of the immunity that was granted? Was we won't use your prospective testimony at the trial as evidence for any criminal charge that may either exist or not yet exist in the past.
well, I think one of the issue or the problem here for her is that if she does change her story, then she's admitting to perjury if she changes it the day of the trial.
How when she has immunity? I mean, that evidence would never get into the trial.
But it would get into the trial through her actual testimony.
No, it would not get into her perjury trial.
Oh, into her perjury trial. Yes.
There's
I
no
would agree.
danger there.
I would agree with that. However, it comes down to then that day, who determines whether that's the truth or not? If she changes the testimony the day of trial.
Let me try to expand a little bit on what Justice Stiegel is pursuing. You're asking us to find in general, not just, any specific facts of this case, but in general to find that the Fifth Amendment precludes that the Fifth Amendment protects testimony on a future charge of perjury. Okay? And that means that what we decide in this case will apply regardless of whether someone has ever been charged with perjury before. Okay, so I know that you're arguing the facts of this case, but your argument necessarily means that for every witness, they will be able to take the fifth, invoke their Fifth Amendment privilege, and protect themselves against perjury.
And I would disagree with that it affects every potential witness. Because this is a very specific situation in which the county attorney had already charged this individual.
But it doesn't make any difference because as Justice Stiegel said, she's already immunized for anything she says at Mr. Adams' trial. Okay, they can't use any of that.
In the current charge.
Her first perjury.
Right.
Okay. All right. So that's a non-issue. I mean, she was granted that and, and they can't do that, but she didn't take advantage of that. But so that's kind of a non-issue. The real issue here is there's only one issue here. And that issue is whether I can, as a witness, invoke the Fifth Amendment privilege against self-incrimination because I'm fearful. So I get to not testify because I'm fearful that I'm going to be charged with perjury. And the United States Supreme Court and every other state and federal court that have addressed the issue basically says the Fifth Amendment does not confer a privilege to lie.
And I don't
so-
disagree with that.
Right. So it does apply to every other case. This case is not different because she was immunized. That first issue is, she was immunized. So it wouldn't have made any difference if she testified because they couldn't use that testimony to prove that she committed perjury at the preliminary hearing. Right? So it's as if she never testified in Adams' trial as far as the first perjury.
Right.
charge.
As far as the first perjury. But the problem is the second perjury that the state had made very clear that even going back to preliminary hearing, that if she lied, he would charge her with perjury. And so it's not just a fear of being charged. It's pretty much a given that that's going to happen if she comes in there and testifies consistently with what she testified to previously. And that's where we're saying that the Fifth Amendment comes in and protects her from that.
Why?
Only if the state can prove she lied, right?
It's the state's determination that they came to that she did lie. And that's what started the entire
Right, but
road that we're
But a
down.
jury would have to find beyond a reasonable doubt that she lied.
Correct. And that is what the district court made clear to the state at the time was the state had said, well, I'll just dismiss it with prejudice. And that should be all in the record. And the court's like, that doesn't solve the problem. You've
We're
already.
talking about the past.
Right.
The issue is not the pending charge because she was given immunity. So I'm not really seeing that, to be honest. I'm not seeing that as an issue at all. Okay. The only issue in this case is, can you not testify because you're fearful when you do that you're going to get charged with perjury? And I think the law is clear across the country that, as Justice Stiegel said, if you're a prosecutor, you can say that. It happens every day on the stand. You understand that if you lie, you're under oath and you could be charged with perjury. So do you think it's wrong to say that to a witness?
I think it is coercive to a degree to say that to a witness, especially after you have already charged them with perjury the first time around. I think that is coercive. And I think that is where the Court of Appeals was in a degree, was going with this in their opinion, was that it is coercive.
And that strikes me as the heart of your argument and the Court of Appeals decision.
Yes.
And I guess the difficulty that I think I have with that, and maybe others, is that of course it's coercive. Of course it is. That's why perjury laws exist, to coerce witnesses to tell the truth, to provide a strong incentive to be truthful. So can you address that? Like, I don't think you win just by demonstrating that it's coercive.
No, I think that where this, we had argued this in our brief, was that the court was, or the state was essentially telling her that it believed that what she testified to previously was perjury. And so she was then in a situation of either stay consistent with that prior testimony and face the reality of a potential second felony charge, or change that testimony, whether she changed it to something false or what she testified to the second time, whatever it was. If she changed it, then if it deviated from the truth the first time around, then again, she's committed perjury. So it's coercing her into either staying consistent and getting charged again, or changing her story because the state didn't like the first time what she presented in her testimony, and committing perjury again. So it's essentially state sanctioned perjury if she changes that. That's the situation that she's put into there. And I know that the state argued that they weren't telling her what to say or anything. They didn't have to tell her what to say on the stand. Just coercing her to change her prior testimony is essentially telling her to say something different.
Well, doesn't that, as opposing counsel say, let me go back, necessarily force us to infer that a prosecutor is improperly using a threat of a second perjury charge to get a witness to change their testimony? I mean, we necessarily have to assume malintent.
I don't think that it's necessarily that you have to infer that it's malintent, whether it was that, or whether it was just his verbalization with no intention to cause harm or something of that nature, without it's just something he said. The fact of the matter is, it holds real weight when a prosecutor says that to somebody.
But isn't it, as Justice Stegall just said, yes, it provides a strong incentive to tell the witness to be truthful. I mean, I don't see how that's coercion. Just tell the truth. And I would also ask you that if she wouldn't have told a different story at the scene of the crime, none of this would be, this was basically the factual record demonstrates that she told a completely different story at the scene of the crime. And had she not done that, then we wouldn't even be here today, right?
Well, and I think, and it was included in the facts that were included in the briefs, I think that a big part of this was that she talked about how intoxicated she was the night of the incident, that she didn't remember exactly what she had said. And so,
Well, we're not really talking about that though, are we? We're not talking about memory fading, forgetting. Sometimes memory even morphs where you think you remember something that couldn't have happened. We're not talking about any of that. That's not perjury. Is it?
no, I think that one of the issues with Miss Lang was that and I believe it's somewhere in the record, that she said, I don't remember saying that. I didn't know what I said to law enforcement. I wanted to see my written statement because I didn't remember what I wrote. that was all brought up during the,
But she remembered vividly taking the pulse of the victim. It didn't the court take that into account?
I believe that she mentioned that she remembered taking the pulse of the individual. Correct.
Can I ask one question? The right we're talking about is a personal constitutional right under the Fifth Amendment, and that right belongs to Miss Lang. She's not here. She doesn't have counsel. Is that an issue? Is that a problem? If so, what do we do about that?
I fully anticipated that, that there would be an additional brief that was submitted, but that did not happen, so I'm here. There are no other questions. Don't have any other presentation. Okay.
Very briefly, I do want to clarify something from that Justice Standers asked. I don't want to mislead the court. When it comes to whether or not the prosecutor actually on the record threatened a second perjury prosecution, I don't think that's in the record, but I'm not sure. I'm not asserting that that is not in the record. I don't believe it is, but I've been wrong before. So
the Court of Appeals opinion on page 3 says that at the start of trial, there was a discussion, and while explaining, quote, the state's theory as to why Lang could not assert her privilege against self-incrimination, the prosecutor told the district court he viewed Lang's preliminary hearing testimony as perjury, and therefore any consistent statements would be perjury again.
That it could be in the record. I'm shooting from memory here, so I just want to make sure I'm not trying to mislead the court. I mean, it could be that I don't recall him like face to face with her saying, if you if you testify the same way as you did the prelim, I'm going to charge you with perjury. I don't think that kind of direct thing happened, but obviously if it wasn't articulated, it was certainly implied. I mean, that was kind of the crux of why she was claiming or trying to claim the Fifth Amendment. But ultimately, as the court has already recognized, that doesn't matter, because the threat of charging someone with perjury if they testify falsely or inconsistently with prior statements does not create a Fifth Amendment right.
But what if it was the truth? What if the preliminary hearing testimony was true? Just hypothetically. And a prosecutor, I'm not saying this prosecutor, but hypothetically, a prosecutor said, if you repeat what you said at prelim, I'm going to charge you with perjury. Directly said that. I mean, that seems like imminent peril, and the Fifth Amendment seems to protect protect a person from compelled truthful testimony that would be incriminating.
Well, and that's why we have a court process, and the courts would protect that witness from ultimately being convicted of perjury. Probably wouldn't get past a preliminary hearing, and the prosecutor would probably soon find himself in front of the district.
But the Fifth Amendment in that situation would mean that that witness would never have to say anything on the stand, so they could avoid that peril, right?
I'm not following. I mean, the thing is, if it's truthful, it's not incriminating. It's not incriminating the witness for any past misconduct. It's not.
What if it was truthful and incriminating, I guess?
Well, if it's incriminating, well, then we do have a Fifth Amendment. That at bottom, and this is the problem I have with the Court of Appeals opinion, the Fifth Amendment provides a right to refuse to testify about something that will incriminate you for some past conduct. It does not give you a right to refuse to testify because you just don't want to tell the truth. And that's what we had here. She didn't want to tell the truth.
What you're saying is that the Fifth Amendment does not protect a person against being falsely charged with perjury.
I think
Is
that's
accurate.
That's accurate. I mean, there's no way to prevent somebody from being falsely charged with anything other than.
I mean, because that is the defendant, that is the crux of the defendant's claim. The crux of the Court of Appeals is that the fear of being falsely accused of perjury is enough to justify asserting Fifth Amendment.
And as the state made the argument, and as the dissent made below, that's every witness faces that. I mean, every witness that takes the stand could, in theory, be falsely charged with perjury. Every witness faces that. It's not unique to this witness. There's no Fifth Amendment right to refuse to testify because you think you might commit perjury or might be charged with perjury. I mean, the case law is clear on that. And so again, I would ask you to reverse the Court of Appeals and agree with the dissent below. Thank you very much.
Thank you to both counsel for your arguments in this matter. We'll take this case under advisement.